Hi, my name is Ryan Conley, and this is my position speech for COMM 2140. Imagine working a job that you do not get paid for. Seems fair, right? This New York Times editorial called "Playing College Football as a Job" makes good claims, but does not have the strongest evidence to back them up. So, in this editorial, I'll analyze the first, second, and third claim. Subclaims, and for the first and second subclaim, I will address how both don't have the strongest evidence to back them up and suggest others. In the third subclaim, I will address a whole new subclaim because it really doesn't help support the main subclaim strongly. The first claim states football players at colleges like Northwestern with big sports programs are not student athletes, as the National Collegiate Athletic Association says or claims, but employees. The editorial evidence says the National Labor Relations Board agreed, ruling that Northwestern players on scholarship were eligible to form unions and bargain collectively. My evidence would state a story about in 1960, a college football player by the name of Edward Gary Van Horn was killed in a car accident while returning home from a game. His widow and dependent children were not able to receive his death benefits due to the state's workers' compensation law by the California Industrial Accident Commission. This case between Van Horn versus Industrial Accident Commission was reversed later on account of the descendant receiving the scholarship because of his athletic prowess and participation. This case created the ability for a college player to have a contract of employment with a university in which the scholarship served as a pay for athletic services. The second subclaim states the group that brought Northwestern petition to the National Labor Relations Board, the College Athletes Player Association, isn't seeking a specific share of football revenues or salaries, but better protection for concussions and other injuries, guaranteed scholarships that cover the full cost of attending college, and establishment of a trust fund that players can use to finish their schooling after their NCAA eligibility expires. The editorial uses evidence that says Northwestern has already announced that it will appeal the decision to the National Labor Relations Board. It's really empty, and I guess it supports the subclaim, but my evidence would be that Fred Renzing, a football player at the State University of Indiana, suffered an injury that rendered him a quadriplegic. The Indiana Supreme Court ruled that he was not eligible for workers or employees' compensation due to the fact that he signed an agreement by the NCAA's rules. I count this more favorable towards being stronger evidence for this subclaim due to the fact that it applies more of a personal opinion, a story to it, and it kind of explains why the College Players Athletic Association is asking for not money, but better health and security and financial security for the third subclaim states this is a big deal, or at least the beginning of a big deal. It is found at the beginning of the fourth paragraph. This subclaim is weak and could be replaced by encouraging the football players to use the substitution union theory. This theory, made by Michael Leroy in 2012, came from the National Industrial Recovery Act, which allowed employers to limit organizing campaigns and promoted employee benefits. To conclude, I have addressed the first, second, and third subclaim. For the first and second subclaim, I have addressed alternatives to the evidence support to provide better support for the subclaims. And for the third subclaim, I have addressed a completely new subclaim that will help support the main subclaim. So hopefully, in conclusion, the college athletes and the universities can come to good terms before this turns into a bigger controversy that doesn't have a solution. Thank you for your time. My name is Ryan Conley. Have a good night.